Katie, let me start with you and Georgia and the stakes in this case and what you heard today and what it makes you think.
So it was closing arguments, Ali, and it was 3 hours of closing arguments, which was remarkable, but not really if you consider the fact that there are so many defendants. And I guess the footnote to that would be the import of this case. I mean, it started with 19 co-defendants. It's a RICO case with multiple other offenses. You've already had 4 of those co-defendants played out, some of whom were critical to the scheme to defraud and to try to overturn the Georgia election results. And the reason why I talk about that is because we cannot lose sight of the fact that that is what this prosecution is about. We have taken somewhat of a circus sideshow detour over the span of a number of weeks now to be able to litigate a motion to disqualify, which in any jurisdiction would be serious, but in this particular jurisdiction, it has such import, as you discussed in the setup, Ali, because if Fani Willis is disqualified under Georgia law and procedure, her entire office is disqualified, and then you have to wait an innumerable amount of time for a reassignment, and then the ultimate prosecutorial discretion of that new DA as to whether or not they want to pursue all of the charges, some or none. But after these 3 hours of closing arguments, what we were left with, those of us that have been carefully observing, was the fact that Judge McAfee had a series of questions that he peppered to the defense and not so much to the state. And what he focused on, for me as a lawyer and somebody who tried cases in multiple courts, is the following. You know, you have to have a burden of proof. You know, Jack Smith, for example, when he takes Donald Trump and others to trial, will have the burden of proof to prove his case beyond and to the exclusion of every reasonable doubt. It's a lower burden in this evidentiary hearing scenario, but there's a burden nonetheless, but it's not on the prosecution. It's on the defense. And when you heard the judge ask the defense about whether or not, you know, they understood that something that is suggestive of wrongdoing is not a preponderance of the evidence standard, it made you stop and consider the fact that the judge is carefully weighing the evidence in this case, the testimony that's been provided by a number of witnesses, including DA Fani Willis herself and Special Prosecutor Nathan Wade. But it's worth mentioning quickly, Ali, that the star witness for the defense, and in fact, he was called the star witness by the judge himself because there was these huge promises that were over-delivered by the defense in terms of Terrence Bradley, the former divorce attorney for Nathan Wade. He's the only witness that took to stand twice during the course of this evidentiary hearing, and he was just a big womp-womp for the defense in the end. He refused to corroborate or to affirm what the defense said, which is that he had provided all of this very salacious kind of information behind the scenes about his former client, Nathan Wade. The defense is saying that Fani Willis still got a personal financial benefit. But when the judge asked the defense, well, can you define that? The defense said, well, it's like obscenity. Judge, you know it when you see it. I mean, Ali, that's not an evidentiary standard. Right. That's not evidence. And I think that is what is going to be the important thing for the judge. What is the evidence? Can you tune out the white noise? Can you tune out the pressure, all of the potential optics of a decision, and can you base it on the evidence? And I submit to you that I think the judge in this case is going to do that, and we're going to get a ruling in the next 2 weeks.
That much he's told us, Andrew. What we don't have is when the Florida judge, Aileen Cannon, is going to give us a ruling. And look, one of the things she's become known for is she takes her time with stuff and has been somewhat sympathetic to the Trump legal team's constant requests for more time and more things. But today they got shut down, at least on one front, by the Jack Smith team about this idea that you can't start a trial within a couple months of an election. Obviously, you know a lot about these things.
Sure. I think that there's no question that Judge Cannon in her rulings has favored the defense. Even her reasoning has gone out of its way to find fault with the government and to side wherever possible with the defense in ways that I think continue to be pretty shocking. Remember, she is the judge who was reversed twice by the 11th Circuit before the case was indicted. We do not know the trial date. She did make various comments saying that she thought that the date that was sought by the government in July was unduly optimistic, and she asked a lot of questions of the defense about not having a trial at all, and certainly not in the lead up to the election. I was surprised she even brought up the DOJ internal rule, because the internal rules of the department don't in any way give rights to the defense. They're not enforceable in any court. They're just internal guides to the Department of Justice. And that's something that the judge knows very well, having worked as a prosecutor. So it really was none of her business to raise that. And also, the rule simply does not apply. The rule is about not taking overt actions with respect to someone who's a political candidate shortly before an election. Why? Because you want to give that person an opportunity to have their day in court. Well, this is the reverse. This is an overt case where the government is seeking to have that trial, is seeking to have a day in court. So there was every reason for this not to apply and not for the judge to raise it in court.